Texas is not a state that allows anonymity in the members and founding members of corporate entities. Texas is a state that requires transparency, and the reason why is because what I touched on earlier about the ability to pierce the corporate veil. It's got to be something that a customer, or if necessary, the Texas comptroller can figure out who the members are, who the owners are, such that if there's a need, for example, you own a bar doesn't pay sales tax to the comptroller for liquor sales, the comptroller is going to want to know who the owners are, because those owners are charged with the duty to hold liquor sales taxes in trust for the state comptroller. So the comptroller is going to want to know and going to put those owners' personal assets at risk if those taxes aren't paid. Other states, Nevada, Delaware, etc., they have a different corporate structure. They have different permissive statutes that allow anonymity. You don't have to disclose the individual shareholders and owners of corporate entities, and the reporting requirements are different. And for a lot of people, they feel somehow Delaware offers them some higher level of protection. And I don't disparage Delaware, Nevada, what have you, but I have found, in my experience, they're very complicated. It's a complicated reporting process, and it's complicated to maintain, and it's not impossible to get those records to find out who those shareholders are and to pierce those corporate shareholder and make allegations, especially if you're in a federal court in Texas. You serve discovery requests, you send subpoenas out, people have to appear for depositions. I mean, that information will be gotten. So if corporate entities are being abused, that's going to offer you maybe a month or two of shielding, and that might be enough to hide assets. But if you're doing that with a business entity anyway, you're in business for the wrong reason. So what I would say about Delaware, Nevada, this, that, and the other, Texas offers way more robust litigation protection, liability protection. What it doesn't offer is anonymity, and those are the differences that you got to remember when you're forming an entity, and whether or not you want to use Texas's formation procedures and protocols, because again, no anonymity, but again, are you going to be doing anything illegal? If that's a question you got to ask yourself, maybe you shouldn't be forming a corporation. So back to why you don't want to wait. You have limited time to remove a case from state court to federal court once you're on notice of a lawsuit. It's 30 days from the date of notice of service, and it's 20 days to answer a lawsuit in the state of Texas. And there are these rights of removal are critical. These deadlines to answer the process are critical because rights get waived after a certain period of time, especially in the federal court. It's automatic. You just don't have the right to do it. In fact, you can be sanctioned for wrongful removal that's by you, the attorney who removes, and the client who recommends the removal, both sanctioned. Attorney fee shifting to the other side. The punishment for a wrongful removal can be quite onerous. So it's not something you want to waive lightly, and it's not something you want to do if it has been waived. But that being said, just keep these general guidelines in mind, and don't wait. It's like anything else in life, being proactive. Will benefit you and the company better and your shareholders better.